Major breaking news ready for this, folks? The Supreme Court of Massachusetts. That's right, Taxachusetts, the anti-gun jurisdiction of America, Massachusetts. The Supreme Court of Massachusetts, believe it or not, has found that the state's ban on switchblades is unconstitutional under the federal Second Amendment's right to keep and bear arms. Shocking, yes, although it shouldn't be, because there was a Massachusetts Supreme Court that got spanked in 2016 by the U.S. Supreme Court in the Caetano decision. Let's talk all about it when we get back. Good news from Massachusetts for a change. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks Teach Americans About the Right to Bear Arms. We must learn the lessons of the mistakes others have made, including the Jews in Israel, on 10/7/2023, so we don't make the same mistakes and disarm ourselves here in the United States. All right, folks, so this is good news. Good news. Congratulations to, among others, the Knife Rights Foundation and the Knife Rights, Inc., which has been actively involved in protecting knife rights, not just gun rights, but knife rights, in the state of Massachusetts. The state of Massachusetts had banned the possession of switchblades, and in the case of the Commonwealth of Massachusetts versus David Conjura, who was indicted for possessing a switchblade, allegedly, guess what happened? The Massachusetts Supreme Court, their version of the Massachusetts Supreme Court, it's a fancy name for it, you don't need to know it, but the Massachusetts Supreme Court found that, guess what? Switchblades are protected arms under the federal Second Amendment. The right of the people to keep and bear arms includes the right to keep and bear switchblades because they are knives, and obviously knives are, among other things, in common use and not unusually dangerous. The bottom line is that the Supreme Court of Massachusetts, recognizing that they were facing a situation similar to what they faced back in 2015 and 2016, when they were faced with the Caetano case. You may recall the Caetano case was the United States Supreme Court decision in 2016, a per curiam decision that said that stun guns are protected arms under the Second Amendment and could not be banned for all intents and purposes. And that was a case that arose out of, you guessed it, the state of Massachusetts, the Commonwealth of Massachusetts, that had upheld the conviction of Jamie Caetano, who was found to have possessed a stun gun. Well, a stun gun is not a firearm. A knife is not a firearm. And the Second Amendment talks about arms generally, not just firearms. That's why it's the right of the people to keep and bear arms shall not be infringed, not just firearms. And the Massachusetts Supreme Court, applause to them, did the right thing. They followed the law as they should have and said that knives are obviously arms under the definition of arms set forth by the United States Supreme Court in the Heller case, which, using 18th century lexicographers, i.e. dictionaries, lexicographers are people that prepare dictionaries, quoting Samuel Johnson, Noah Webster. Samuel Johnson is the English lexicographer. Noah Webster is the American English lexicographer. The Supreme Court of Massachusetts said that arms are anything that can be used offensively or defensively, and knives obviously can be used offensively or defensively, and thus they can be used for, among other lawful purposes, self-defense. The Supreme Court actually took it a step further, even though they did not need to, because as you know, the U.S. Supreme Court has made it crystal clear that modern firearms and modern arms are protected today, even if they did not exist at the time of the founding. So semi-automatic revolvers did not exist in 1791 at the time of the founding, and yet they're protected arms. In the same way, the telephones, radios, computers, the internet, social media, all these things don't exist or did not exist at the time of the founding, and yet they're protected under the First Amendment. So too modern firearms or modern arms are as well. But nevertheless, the Massachusetts Supreme Court actually went back and did some historical work and talked about how, at the time of the founding, knives were prevalent not just today, but also at the time of the founding. As to how they established that knives today were in common use by Americans for lawful purposes, they pointed out that in over 40 states today, it's perfectly fine and lawful to have a switchblade. No big deal. It's just a knife. Right? The fact that it has like some sort of special mechanism doesn't change the fact it's just a knife. And there are a lot more dangerous knives out there, to the extent it's even relevant, which is really not, than a switchblade. Hatchets, axes, and so on, very dangerous stuff. There's no bans out there. In fact, you can go to Home Depot or Lowe's now, I presume, and buy axes and hatchets without a background check or anything like that. It's ubiquitous at the time of the founding, obviously, for cutting wood, building log cabins, and of course it's ubiquitous today in American contemporary life. It bears mentioning some great quotes that came out of this case by the Massachusetts Supreme Court. Here's a great one talking about how pocket knives, or the switchblades, are well within the definition of arms and must be protected under the Second Amendment. This is what the court said. In short, folding pocket knives not only fit within contemporaneous dictionary definitions of arms, which would encompass a broader category of knives that today include switchblades, but they also were commonly possessed by law-abiding citizens for lawful purposes around the time of the founding. And then again, the court goes on and talks about in common use. And I want to remind you, write this down, very important. When you deal with the in common use test, when it's in common use by Americans for lawful purposes, there's two critical things to understand. The first one is it's not limited to self-defense. The Supreme Court in Heller talks about in common use by Americans for any and all lawful purposes, including but not limited to self-defense. So they're not limited to self-defense. You must understand that merely possessing weapons, firearms or handguns, knives, whatever, for any lawful purposes makes them in common use. Number two, the burden of proof, and this is very important to understand this. This is what makes you the smartest person in the room. The burden of proof in the in common use fight is on the government to prove that something that they have banned, an arm that they have banned, is not in common use. Did you hear what I just said? The burden of proof to show that an arm is in common use is not actually on the Second Amendment proponent. The burden to show that something is not in common use and thus can be banned is on the government. And why is that? Because in the text first, burden shifts to the government to show a historical tradition of a particular type of firearm regulation. The burden is on the government at the historical tradition point to show there's a historical tradition of a kind of analogous gun control or arms control law that justifies the modern gun control or arms control law. Because it takes place at the historical level of the text first, burden shifting to the government to do the historical analysis. Because the in common use test in Heller arose from the historical part of the historical tradition of a particular type of arms regulation, the burden of proof is always on the government once you get to the historical level of the text first, the history analysis second. Thus, the in common use test, which is part of the historical analysis because it derives from the history of banning the carrying of dangerous and unusual weapons, which is a historical traditional test, right? It's a historical tradition of banning the carrying of dangerous and unusual weapons. That's history. That's historical laws. It's part of history. And because it's part of history, you know what the answer is. Because it's part of the historical analysis of firearms or arms laws, the burden of proof is on the government to show that something is not in common use. So with that said, don't ever forget that. With that said, here's what the Massachusetts Supreme Court said about in common use as applied to these switchblades, to these knives. This is what the court wrote. To determine whether a weapon is in common use today, most courts have chosen among three statistical approaches. 1, raw numerical commonality, examining the total number of a particular weapon. 2, proportionate commonality, examining the proportion of a broader class of weapons that are the specific weapon in question, such as the percentage of firearms that are assault rifles. And 3, jurisdictional commonality, examining the number of states that allow the possession of carrying the subject weapon. Now, we don't need to get into which of these is right, because most of the time when we're dealing with semi-automatic rifle bans like an AR-15 ban or magazines that hold more than 10 rounds, whatever the number is, it's overwhelmingly going to be satisfied. Also known as you know, you're going to correct me, the government cannot possibly show that magazines that hold more than 10 rounds or semi-automatic rifles are not in common use. It's simply impossible for them to do that once the burden shifts to them. It's not possible, which is why I keep saying that if the Supreme Court takes that Bianchi case, I think it has a new name now, but if it takes that case dealing with AR-15 bans out of Maryland, we're like 99.5% chance going to win that case, because it's pretty clear there's no way that the anti-gunners can win that argument. We just need the court to take the case, and we'll see what happens very soon. But let me just finish off with what the Massachusetts Supreme Court says in finding that the Massachusetts law that bans switchblades was unconstitutional under the Second Amendment. The court also wrote the following, quite interesting. Today, only 7 states in the District of Columbia categorically ban switchblades or other automatic knives, and only 2 states impose blade length restrictions of less than 2 inches. From these facts, we can reasonably infer that switchblades are weapons in common use today by law-abiding citizens for lawful purposes. More specifically, we can infer they are widely owned and accepted as a legitimate means of self-defense across the country. So, powerful language correctly applying the Second Amendment. This is not a close call. These knives are clearly in common use, ubiquitous across the United States. They cannot be banned in my view, and I'm glad to see that the Massachusetts Supreme Court actually agreed with my assessment. I'm shocked because Massachusetts tends to be full of anti-gun liberals, as you well know. Nevertheless, in this one case, dealing with these knives, it got it right. And I'm glad to see it did so. All right, folks. Well, there you have it today. Hope you learned something here at the 4 Boxes Diner. Make sure you follow me on X at 4 Boxes Diner. And we will talk to you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.